This is Brad Newberg, and I'm a partner in McGuireWoods Intellectual Property practice. I focus my practice on copyright, trademarks, trade secrets, domain names, dilution, and unfair competition. Welcome back to Frenemies, the series where McGuireWoods intellectual property and data privacy and security teams help marketing and legal departments understand each other, work together, issue spot, and maybe go from frenemies to friends. We're in season 2, Companies Don't Share IP, the Use and Protection of Content. And today's episode is the one where they borrowed from their neighbors, when and how to use others' IP lawfully. So we have a short amount of presentation time today and a decent amount of subjects. So think of this as sort of a tasting platter to give you an idea of the types of issues you will encounter and really how to think about them. Some of the issues that you will encounter will be very fact-specific. So if you're in marketing or branding, you should never hesitate to contact your in-house or outside counsel. The two main issues I will be going over today are factors to consider when analyzing the legal risk in a product or a packaging launch, as well as the pitfalls that come up when using third-party content in your marketing or advertising, the latter of which will be most of the presentation. However, let's start with the factors to think about related to the launch of a product or packaging launch or other brand. One of the best things we can do to make friends out of frenemies in this presentation is not just get marketing and legal talking, but to get them talking at the right time. That way, no one feels like the bad guy or that they're being babysat or they've got too much time and money invested in a product or a launch and they feel like they can't go back. We want everybody to be operating as teammates. Basically, there are two levels of risk assessment. The first is more of an informal one, what I would call a gut check. Hey, we're considering X, Y, and Z. Do any of these sound crazy to you? Or are there any competitors out there who have registered a mark just like this? Is it going to be protectable, or is it so descriptive that we're going to put all this money into it only to find that pretty much anybody else can use it? Questions like that. This is the time for legal to tell marketing that, hey, this brand may be telling the consumer exactly what they're going to get, but that also can mean less protection. Or I just checked and there are 73 other companies that use this word in their registered mark, and 6 of them are pretty close to our market. And that's really the type of search that can be done very quickly. So what's more involved in a formal search is that the type of thing where you feel like, okay, if this looks good, we're moving forward. We're going to have implementation, we're going to have design, we're really ready to go. And those searches check the federal registries, state registries, domain names, business entities, to really see what's out there that's close in your space. The search might come back with a much more crowded or worrisome field than you expected, or it might say this is not only good to go, but is likely to be a very good, strong, protectable brand. It's the type of thing you want to do before putting a lot of money in, so you can pull out if you need to, but not when you're just spitballing ideas. You also want to have done in time to get things like trademark applications on file if you really want to beat someone else or an opportunistic infringer to the punch. You know, at this point, people really like the mark or the packaging, the trade dress, the branding, and they really think if this search goes well, we're going to be doing okay here. We're going to be going forward. And you have to really think about the product marketplace you're going to be putting this in so the proper searches can be done. The next thing you want to do when you're moving forward brands or trade dress or packaging is to make sure you have all the possible rights that you can. Did you hire any third-party companies to help you? If so, what does your agreement with them say? Because if they're not an employee acting in the scope of their employment, you're going to want to make sure the contract really assigns all intellectual property to your company. It should also indemnify you in case third-party company took the content from somewhere else and it didn't happen to mention that to you and you get sued down the road from someone else. This goes also for anything from marketing companies to website development companies, your manufacturers, companies you might be co-branding or you've co-branded in the past, and this is just an extension of a brand. And if employees worked on the designs, the ideas, you're typically okay if they are employees acting within the scope of their employment. But it's good to make sure your policies or your employment agreements also clearly state that. And for instance, if you had someone who on their own was working on some art design at home and might not be in the scope of their employment, you're going to want a separate agreement even though they're an employee, because something could be considered outside the scope of their employment. The best thing you can do for everyone's sake is to make sure that everything out there is as clearly spelled out as possible. Before we leave this topic, I do want to throw out some additional questions that are going to come up when you're analyzing this sort of risk and you're engaging in this analysis. For instance, what countries will you launch in, but also what countries will you eventually launch in? If your biggest market is the United States, but your second biggest is Germany, you're not going to want to spend a year developing the brand in the United States only to find out that the mark can't be used in Germany. And these sorts of analyses that we're talking about, and the formal searches and the risks, they go country by country. The risks will have to be analyzed for each and every country that you want to launch in. You need to also think about questions like, if you discover a potential adversary, how big are they? How litigious are they? How much of a black eye would it be to your reputation if you got into a battle with them? What's your ability to pay for a large litigation budget? And also think about, are you far away enough from their goods and services now that it's safe, but you might actually be thinking that you will want to expand into their goods and services in the future. Again, you don't want to invest so much in a brand that you can't use for your business plans down the road. We're now going to move into various issues that might come up when you're using third-party content in marketing your goods and services, and when third-party content comes into play. We've sort of arranged these into the types of pitfalls and potential pitfalls you might get into and the best practices related to them. Because even though nothing is foolproof, you want to put your company and yourself in the best situation that you possibly can and feel like you did the proper thing, even if there's trouble down the road. Now, the first thing I want to discuss in these pitfalls is the use of materials you find off the internet, specifically images. A lot of people use images in their marketing and in business, and the first place many people go is a search engine like Google, and they'll look for an image. So let's say you find something you really like. What can you do with those images? So let's say you're reviewing or clearing or trying to find some sort of material, and it's going up on social media, or it's going in advertisement or on your web page, and it's going to partners or customers or the public, and you do a search and you find the perfect photograph just sitting there on Google from some random publicly available website. What can you do with it? So given the structure of this webinar, I obviously can't ask anyone listening to raise their hands, but really think about what you would say the answer is. Is it, number one, I can use them as long as I give attribution to who created them or where I got them. So for instance, putting up a disclaimer or a note saying it's from this site or the photograph was taken by Phil Smith. Number two would be I can use them as long as I don't change them. So you can't mess around, you just have to take the photograph as you find it. Number three would be, well, they're on Google, they're freely available, I can use them. I mean, someone put this up on the random site, they must have known people could search for them, they must have wanted people to see them and to use them. And then 4 and 5, number 4, I can use them as long as I make some changes to them. And that would be the flip side of number 2, right? You actually can't use it exactly as is, but it's okay if I use it as a base and I just change it around. And number 5 being, I can use them for an idea to create my own images, but I can't make copies of them or recreate them. And so, okay, I see a happy, smiling family in front of a house. That's a good idea. I should get some photographers and some models and do something with a happy, smiley family that's a little different. So the answer is number 5 and only number 5, that you can use the idea. And the important part here is the idea. An idea versus expression is a very important line in law. And you can use them for ideas to create your own images, but you can't make copies of them or recreate them. You can say, I like happy, smiling families in front of houses, if that's what you're looking for, and you can try to create something like that. But you can't take someone else's work, you can't make copies of it, and you can't just recreate it by casting lookalikes and putting them in the same position in front of the same house. Every photograph, no matter how basic it seems, is copyrighted and is owned by someone the second that person clicks the button on the camera. Similarly, for artwork, it is owned the second pencil or paintbrush is put to paper or canvas. Now, there are certain fair uses for various things, including for, say, educational purposes, like, say, this presentation. But if it's going to go into something for marketing or widespread external use, it's highly unlikely that a business's use in marketing is going to be considered a fair use. So what are the best practices when using third-party content? Especially if you don't want to recreate the wheel and you actually want to use content that's out there. Well, first, you need to identify all content you plan to use, and you need to figure out where that content is. Make a game plan before you start. Secondly, if you don't know that you have the rights to it, you're likely going to need permission. Decide whether that's worth it to you, or if there's something you already have rights to that can do the job instead. And if you can't figure out who owns it, or if you can't figure out if you have the rights, don't use it. If you need it, determine whether a license is actually needed, and if so, get it. Now, there are public domain things out there, material on the internet that is still public domain because it was just pasted there from something that's over 100 years ago. 100 years is a decent benchmark. But never assume that something is not protectable at all. Now, if you're using the materials on a third-party site, you also need to consider something like Facebook, Twitter, etc., the terms of use and what they would say about your material. Because often a copyright violation would also be a violation of that site's terms of use, subjecting you or your company to possible expulsion from that social media site. And you do not want to be the one that gets your company's posts or even their accounts removed. Now, let's say you are working with people internally who are frequent users of images because they're putting together many different pieces of marketing or advertising or branding. You want to train them or you want to set up your own policies. You want to be encouraging everyone to know the materials that you have rights to and to use them and to get the proper permission. So one thing you can do is keep a database of your own copyright images and other content that was created at the company through employee scope of their employment. And you want to make sure everybody knows where the database is. The database is useless if people aren't educated about it. And the same goes for content for which you do have a license. Educate those that are working with content to go to the areas in your website on your server where they have appropriately licensed content. Maybe you have an account with a stock photo license agency that they can go to and train them what they can do and how they can use that photo license. Make sure also that every license and permission covers the intended use, timing, geography, and any restrictions. Again, it's useless if you point employees to the database, but then the use is outside the scope of the permission, because you can't assume that one use that is permitted extends to all uses. You might actually have a license for use of a photograph on a web page or on social media, but that doesn't mean you could use the exact same advertisement in a print ad. So also, if legal actually cleared something as a fair use you don't need permission for, that doesn't mean you don't need permission for any uses of that image or third-party material. It's important that you go back to legal for each new use because fair use is decided on a case-by-case basis. And always maintain clear records for your licenses and various permissions. I cannot tell you just how many lawsuits I have seen that have occurred or been filed many years after the fact, where the company is sure they licensed the material, but they cannot find the license, and it's so many years that the employees that worked on the advertising or the marketing are no longer there, and they really don't have anyone to dig back up what had happened or figure out the course of how the license was gotten or where it was gotten from. So a lot of people also want to link or embed videos or articles. So one of the things I want to point out is that the best practice does not involve copying or reposting things, even if they're super interesting on your website or social media account, especially for an article. You can use a headline. You can use a very, very short description of the article, but you should be putting a link back to the original article. Now, a grayer area is embedding content. So YouTube, Twitter, other social media entities often have embedding, which is the process of sort of opening a window on your website that sort of goes through your website, opens a window so you can see another website without copying the content onto your server. And that is typically considered not a violation. However, there is a minority view of the law that says it is. And there are people who have tried to sue to say that they're even embedding their work without permission is a violation. I'll give you a quick example. A couple of years ago, a guy sued a whole bunch of major media companies in federal court in Manhattan for embedding his Twitter page, where he posted a picture he took up Tom Brady of the Patriots visiting with Danny Ainge, general manager of the Celtics in Boston. Many people thought the suit would quickly fail, but his position was the court above the district court, the Second Circuit Court of Appeals, had never actually definitively decided the issue. Well, it turns out the district court agreed with him. And while that may not be where the law is actually going or where the circuit courts, or even if it happens to go to the Supreme Court, will end up, if I'm giving you the most conservative view, it would be to stay away from embedding and link to the site where a photo or a video is. So let's talk about the use of trademarks. The whole point of trademark law is that a mark identifies one and only one source and specifically shows some sort of authorized relationship between two companies. So the question whether one company who's using a trademark owner's mark is breaking the law is actually a fairly simple one. It is it likely that consumers of the company using the trademark owner's mark will believe that the goods or services coming from that second company actually came from the trademark owner, or that there's an affiliation or association with the companies, or that there's some sort of sponsorship when that's not the case. So here are the basic rules. Just as you want to make sure that your trademarks are solely used as an identifier for you and those with whom you have licenses, that's what other trademarks want, trademark owners want. So you don't want to ever imply affiliation with another company or its marks or products or services unless you have a license to do so. You also want to be careful how you use third-party marks when selling goods or services. Sometimes also you will need to refer to another company's brand. You may be selling goods or services of others, and you want to make sure it's clear that that's what you're doing. If you're selling or just if you're discussing the trademarks of others, you also want to make sure you have the disclaimer saying to whom the trademark belongs, saying that you have no affiliation with that company, or make sure the language you're using makes it clear no one's going to be confused. And if you do have a license, note that, and note that the trademark is being used pursuant to permission from the other company. And the same thing goes for comparative advertising. So comparative advertising is a time where obviously you have to use the the other side's trademark because you aren't doing comparing of your goods and services to theirs. But you want to use as little of their mark as possible in the advertising that will get your point across. You want to make clear there's no affiliation. And when I say use as little as possible, that may even go to things like, instead of using a logo, use their word mark. You also obviously want to make sure that everything is truthful, because you can be on the hook for things that are directly false, but also misleading or things that have material omissions. And the more you're using someone else's trademark, the more you have to be on the right side of that line. Now, I'm going to talk a little bit about keyword search advertising and other search engine optimization issues. You should keep in mind that these things I'm going to say go both ways. They're things you should keep in mind when you're using potential marks or search terms and you're buying advertisements online, but also when you're doing searches of your own company and you see things come up that you think, well, does this look a little fishy, sketchy? Should I be reporting this to legal or getting outside counsel involved? So let's start by talking about keyword advertising. Keyword advertising is not as much of a Wild West as it used to be. It's still a very big business. As many people listening to this might know, keyword advertising, the most famous of which was always Google's AdWords program, is the purchase of a term, sometimes a trademark, so that when the internet users put that term into the search engine, that along with the organic search results that come up due to the search engine's algorithm of what they think the user wants to see, this advertisement will come up usually on the top or side of those organic results. The question has always been, is that fair competition, or is it free riding in an illegal way on the goodwill of well-known marks? And the two examples that I like to sort of put out there of how to think about it are what I loosely term the highway billboard or the supermarket placement. And a highway billboard is, let's say that you have two companies, and I'll just name two companies, obviously just for purposes of this this webinar. Let's say there's Target and Best Buy, and Target buys a billboard on the highway that says, hey, if you want to come to Best Buy, get off the highway, go a mile, it'll be on your right. And you get off the highway, and you get there, and you see it's Target. It's not a Best Buy, even though that's what the ad had said. Well, you know it's not Target. You know it's not Best Buy at that time. That's a Target. But you think, well, I was needing a camera, and they sell cameras. I'm going to go in there. Even though you know at the time going in that it's not the Best Buy, many courts would say, well, that's misleading to the point that it is an infringement of trademark. On the other hand, let's say I'm a small cola company, a small soda company, and I ask the supermarkets, hey, can you put all of my soda right between Coca-Cola and Pepsi, because those are the two big brands, and I want to make sure that when someone's looking for Coca-Cola, they can't help but see my soda. Well, that's also use of their trademarks to help your company, but that's something that's typically considered okay. So which is keyword search advertising? Is it when you buy a trademark? Is it more the highway billboard or the supermarket placement? So in the United States, most courts have come out to say it's more like the supermarket placement, that the mere purchase of the trademark by itself for a search term is not infringement. What depends upon is it depends upon what you do with it. So meaning, what is the resulting ad text? Comparative ads, where no one would think the advertiser and the brand are related, are okay. Where it says, oh, you were looking for this, we think you might like this other product. What's not okay is saying, click here and you're going to get to this brand, and then they get to this other website instead. So the advertising text is what is looked at as to whether you're going to have an internet user being confused into thinking the ad came from the trademark owner or there's some sort of official affiliation. So if you ever decide to do search ads for your company, that's what you should be thinking about. You can also use those rules as a guideline for when you see search ads based on your own trademark. The other terms people think about are metadata and invisible text. Metadata is code that people put in their pages that search engines used to look for, even though the internet user can't see them. I generally tell people don't use them, mostly because the search engines really, for the most part, don't look for them anymore. And there's still some case law out there that could say that that would be a bad thing to do. Invisible text would be putting, for example, McGuireWoods put another law firm's name all around their website, but put it in white letters on white text. So an internet user couldn't see it, but search engines could. Again, that could be considered fairly sketchy. It could also be bad for your reputation if that comes out. And again, search engines have gotten pretty sophisticated. So it's another thing we typically recommend that you don't do. We're going to be having a Frenemies episode on social media that goes into more detail on hashtags and domain names. So I'm just going to touch on them briefly. The big takeaway is that advertisements must always look like advertisements. A hashtag can satisfy that sort of disclosure, but it has to be prominent, and abbreviations might not work as they might not be clear enough. Plus, if you encourage others to use the hashtags, you need to be okay that you're going to lose control over that posting, and the posters are still going to have their own publicity rights, and they're going to have their own rights in everything they create around those hashtags. So you want to be clear about that and know that once you put that out there, that's going to get away from you in certain ways. And if you want to have a mind of its own, that's okay. But you should also act as if a hashtag is being used as a trademark. It can be hard to get rights from use of a hashtag, but it can be thought of as infringing if it creates confusion in the marketplace. So you need to analyze the same factors we discussed earlier so that you don't get sued for using something too close to a competitor's trademark. Domain names like hashtags might or might not create trademark rights, but they can certainly be looked at as infringement if they create confusion. So you want to, again, think of those risk factors the same way as if the domain name is a trademark and whether it's too close to a competitor. You wouldn't want your domain name frozen or taken from you, something that can actually goes much quicker than a litigation through something called the Uniform Domain Name Dispute Resolution Policy. Also, be mindful of the new GTLDs, which can range from anything from .bike or .camera or so on. Traditional ones, of course, as you know, are .com or .net, but now there are 1,000. So it might be worth it to register your domain names in the most pertinent new GTLDs to avoid wrongdoers going for similar names with just a different ending GTLD. Finally, I should mention, even lawyers have to engage in this sort of what you might call mind-numbing activity when they market or when they do things that are external, so you don't feel too bad. In this presentation, it was educational, so we do get a little bit more leeway in what we can do, but we still always wanted to think of third-party rights. We want to think of them and use them in a way that no one's going to think we're affiliated and use as little as possible to get the point across. We obviously knew the series would be a parody of Friends, but did it in a way that got the point across without using copyrightable creative content in an unfair way or trademarks certainly in any way that would imply affiliation. We were asked questions like, can we use the font and design? We decided not to. Or can we use videos or images? Also, we didn't do that, even though there might be arguments that in an educational presentation, it would be fair use. The point being, rest assured that we go through the same sort of analysis as lawyers that we ask our clients and our clients' marketing teams to do. So thank you very much for joining me for Frenemies Season 2, Episode 1. Feel free to reach out to me or any of my colleagues if you have any questions or would like any more information on the content covered. Now, all episodes on Season 1, Cross into the Friend Zone, Trademark 101, and Season 2, Companies Don't Share IP, the Use and Protection of Content, are currently available on McGuireWoods.com. Also, keep your eye out for future seasons in the series, which will be available for binging soon. Thank you very much.